How was copyright originally protected under the Statute of Anne? What sorts of works were protected? And how long did copyright last? The Statute of Anne, also known as the Copyright Act 1709, is an Act of the Parliament of Great Britain passed in 1710. The Act was the first statute to provide for copyright regulated by the government and the courts rather than by private parties. What was the purpose of the Act? The statute was introduced as an act for the encouragement of learning, by vesting the copies of printed books in the authors or purchasers of such copies during the times therein mentioned. Why was the Act introduced? Prior to the introduction of the Act, copying restrictions were contained in the Licensing of the Press Act 1662. These restrictions were enforced by the Stationers' Company, which was a guild of printers who were given the exclusive power to print and the responsibility to censor literary works. In 1694, the Stationers' power came to an end after Parliament refused to renew the Licensing Act. Over the next 10 years, the Stationers petitioned for the reauthorisation of the old licensing system, but Parliament declined to enact any new bills. Finally, the Stationers succeeded in getting Parliament to consider a new bill after they emphasised the benefits of licensing to authors rather than publishers. What sorts of works were protected, and how long did copyright last? The Statute of Anne was the first act to directly protect the rights of authors. The Act limited the exclusive right of publication to a set term of years and contained other provisions which limited the power that was previously enjoyed by the Stationers. The legislation outlined the nature of copyright, with the right granted being the right to copy, to have sole control over the printing and reprinting of books, with no provision to benefit the owner of this right after the sale. This right was automatically given to the author as soon as the work was published. The Statute of Anne was limited to books, i.e., literary works. For existing works, authors or their assigns were granted the exclusive right of publication for 21 years from the effective enactment date of the Act being April 10, 1710. For new works, the author was given the exclusive right for 14 years from the date of publication. If the author was still living at the expiration of the first term, they were granted the privilege of renewal for 14 more years, making a total of 28 years. This right was automatically given to the author as soon as the work was published, however they had the ability to license these rights to another person. Once the copyright term ended, an author's work entered the public domain, meaning that anyone could print or distribute it without obtaining the author's permission or paying a royalty or fee to the author. An author could gain copyright through two stages. First, through the registration of the book's publication with the Stationers' Company, whereby a notice of registration was required to appear in every copy of the published work. And second, a deposit of 9 copies of the work for use by certain libraries of the kingdom was required, which included the Stationers' Company, the Royal Library, and various universities. Once registration had been completed and the deposits were made, the author was granted the exclusive right to control the copying of the book. Penalties for infringement of this right were severe, whereby all infringing copies had to be destroyed and large fines were to be paid by the copyright holder and the government. While the Act secured the interests of the stationers and regulated the general operation of the book trade, it must be remembered that the primary concern of the legislation was ultimately for the encouragement and advancement of learning.